The Supreme Court repudiates James G. Blaine. Good afternoon, ladies and gentlemen. This is another declaration of truth from your host, Terry A. Hurlbutt. Yes, yesterday the Supreme Court released 5 more opinions, and one of them, Carson versus Makin, is going to be a landmark. The case, while it builds on several previous cases, does break new ground in clarifying the Establishment Clause of the First Amendment. We're going to talk about how it corrects a wrong-headed course this country has been on for 147 years. The atheists, beginning with President Ulysses S. Grant and Representative James G. Blaine, Republican from Maine, have lost the Establishment Clause, and that means our Great Awakening just got an order of magnitude easier. Before I begin, I do want to shout out to the sponsor of this channel, which is Conservative News and Views, link in the description. Be sure to check out the awesome CNAV Store. Scroll down near the bottom for that link. Lots of good merchandise there, including this t-shirt that I'm wearing, the Trumpinator, saying, "I'll be back." All right, ladies and gentlemen, lift up your voice. Rejoice. I say again, rejoice. Before I go to today's case, here's an update on the Supreme Court and the status of opinions still outstanding. This morning, the court posted a 3rd opinion issuance date for Friday, June 24th. The 5 opinions the court released yesterday did not include any in Dobbs versus Jackson Women's Health Organization. So that case is one of 13 cases left for the court to decide. Other key cases waiting for decision include, without limit, New York State Rifle and Pistol Association versus Bruin. That case will decide whether or not New York State may refuse concealed carry permits in typical cases. Kennedy versus Bremerton School District. Coach Kennedy lost his job because he prayed with players after games. Naturally, he wants his job back, and if he gets it, that will further move the cause of religious liberty. Biden versus Texas, concerning whether President Biden had the authority to rescind President Trump's Remain in Mexico policy. West Virginia versus Environmental Protection Agency, on whether or not the EPA may regulate carbon dioxide as a pollutant. In compiling this list, I tip my hat to Rolling Stone, which provided all the links to in its article about the Carson case. As Sun Tzu would no doubt agree, even one's enemies may provide valuable intelligence on occasion, and sometimes you don't even have to spy on him to get it. The Supreme Court could issue all 13 opinions over the next 2 days, or they could issue all but 3 to 5 of them and issue those next week. We just don't know what they will do. But we do know this. Yesterday, the Supreme Court released an opinion that promises to have a much further reaching impact than Dobbs ever could. The reportage on the Carson case comes from, among others, New York Magazine, Rolling Stone, as I said, CNN, and NPR. We also have commentary from Eric Woods Erickson, the political junkie of Atlanta, Georgia. And better than that, we have the opinion itself, and I have a link in the description to that opinion. David and Amy Carson and Troy and Angela Nelson live in 2 different towns in Maine. The state of Maine, which Chief Justice Roberts called the most rural state in the Union, has a problem. Like every state, Maine has a constitutional requirement that towns and counties provide free public schools to their residents. But the sparse settlement and long travel distances make this next to impossible. Maine has 260 school administrative units, or SAUs. All provide elementary schools, but fewer than half can afford to provide secondary schools. The towns of Glenburn and Palermo, where the Carsons and the Nelsons live, do not have that favor. some SAUs can contract with their neighbors to have their secondary school age students go to the neighboring middle and high schools. But Glenbard and Palermo can't even afford that, and their problems are typical. So, the legislature long ago set up mandates and funding for tuition assistance for parents who live in such SAUs. Vermont does the same thing. Thus, Glenbard and Palermo and other communities like them can pay the tuition at the public or approved private school of a parent's choice. The problem is that in 1981, Maine passed a law that only non-sectarian schools could get approval for tuition assistance under this program. The roots of that law go back to 1875 and a thoroughly atheistic plan by President Grant and Representative Blaine. Before that year, many states had close ties to churches. All that the First Amendment forbade was the establishment of a Church of America. In addition, the Constitution, Article 6, denied any authority to impose a religious test for holding office. But that did not satisfy President Grant, so he sought to amend the Constitution to fund free federal public schools and refused to fund religious schools. Representative Blaine introduced this proposed amendment in the House. It passed, but failed by 4 votes in the Senate. Why did they do that? Well, Erickson tells us that Grant and Blaine sought to slow the immigration of Irish and other Catholics into the country. A system of government atheistic schools was to be their means of stopping that inflow. When the Senate refused to send that amendment to the states, Blaine traveled the country and persuaded most states to so amend their own constitutions. 37 states have Blaine amendments today, but oddly, Maine is not one of them. For this reason, New York features a photo of Blaine, calls him, and I quote, Maine's and America's great champion of church-state separation, unquote, New York Magazine. But when they try to suggest that Blaine was merely copying Jefferson, they clearly get it wrong. Again, James Madison intended, with the Establishment Clause, to forbid a Church of America with salaries for its clergy and laws forbidding anyone to worship anywhere else. Instead, the Supreme Court, beginning at least with Everson versus Board of Education of Ewing, 1947, took the position that absolutely any funding of any institution having a religious character constituted an establishment of religion. That would have been used to Jefferson and even to Grant and Blaine. Look again at the text of the amendment Blaine tried to get Congress to propose. No state shall make any law respecting an establishment of religion or prohibiting the free exercise thereof, and no money raised by taxation in any state for the support of public schools or derived from any public land therefore, nor any public lands devoted thereto, shall ever be under the control of any religious sect, nor shall any money so raised or land so devoted be divided between religious sects or denominations. Close quote. Now, if establishment of religion really meant to include funding of religious schools, why mention that separately? Blaine knew what he was doing, and that language was not in any way redundant. Over the decades, the Supreme Court declared hostility to religion. In essence, the Supreme Court has made case law respecting an establishment of atheism or secular humanism as the official state anti-religion. I go further. I say that these precedents really underlay Roe versus Wade. That's the background of the Maine law, the Blaine law. The Carsons and Nelsons decided to sue it away. The Court of Appeals for the First Circuit found for Maine, but yesterday the Supreme Court reversed that judgment. Before I get down to those details, I'll shout out to another sponsor, BitNext. This is your replacement for Zoom, Slack, the Google G Suite, Microsoft Office 365, Dropbox, WeTransfer, and Chili Piper, among others. Unlike any of them, BitNext protects your content and conversations so well that even the administrators can't see it. So this is your channel for secure comms, conferencing, cloud storage, and file sharing. Best of all, everything is backed out, so you don't even need client software. If you have a browser, you can use BitNext. Follow the link and give them a try. 28 days free of charge. You can't beat that with a stick. All right, ladies and gentlemen, let's get back to the opinion of the court in Carson versus Makin. Chief Justice Roberts charts how the Supreme Court has started to walk back this hostility toward religion. In Zellman versus Simmons-Harris, 2002, the court specifically held, and I quote, a benefit program under which private citizens direct government aid to religious schools wholly as a result of their own genuine and independent private choice does not offend the Establishment Clause, unquote, the Supreme Court. Shortly after the Zellman case, Maine's legislature considered repealing its non-sectarian requirement. That proposal failed. But in 2017, the Supreme Court in Trinity Lutheran Church of Columbia Incorporated versus Comer held that no state-made NI funding otherwise available to others merely because the applicant was a church. At issue was a Missouri law that provided grants for resurfacing playgrounds with cushioning surfaces from recycled auto tires. Pretty good idea, I say. Then, in 2020, while the Carsons and Nelsons were appealing to the First Circuit, the court made another related ruling. In Espinosa versus Montana Department of Revenue, the court directly held that Montana's Blaine Amendment is unconstitutional. At issue in Espinosa was a scholarship program available only to students at non-sectarian schools. Missouri has a Blaine Amendment also, and the court's action in Trinity Lutheran certainly looks like a strike against it. And in the 2021 term, the Supreme Court held in Shirtleff versus Boston that the city of Boston could not refuse to let a religious organization fly its flag in front of City Hall if other organizations had the same privilege. Accordingly, in the Carson case, the Supreme Court held that Maine, having decided to provide tuition assistance, may not refuse it to religious parents. Maine does not have a Blaine Amendment, but it does have that 1981 law. So let's call it the Blaine Law. The only reason for that law was an opinion by Maine's then Attorney General that the Establishment Clause required it. No, the Supreme Court said yesterday. Not only that, but to refuse the funding violates the Free Exercise Clause. So Roberts inferred from the Zellman case, and the Conservative Five, Alito, Barrett, Gorsuch, Kavanaugh, and Thomas, agreed with him. The Maine Commissioner of Education, that's the Makin as in Carson versus, tried to argue that his case was different from the Trinity and Espinosa cases. His theory that the instruction the two religious schools offer clearly includes encouraging non-believers to believe. So, Commissioner Makin invoked another case, Locke versus Davie, where the court did disallow tuition assistance for a religious school, but that particular school offered a program to prepare students to go to seminary. That doesn't apply to the Carsons or the Nelsons. Finally, Roberts reminded the Maine Department of Education that they could avoid the issue by not providing tuition assistance. They could instead provide funding to build more middle and high schools, build a bigger bus fleet, provide tutoring, remote learning, partial attendance, or some combination of the three, or even build and operate state boarding schools. But having decided to assist with day school tuition, they must make that assistance available for all schools, secular or not. As I mentioned, Alito, Barrett, Gorsuch, Kavanaugh, and Thomas agreed with Chief Justice Roberts, but Breyer, Kagan, and Sotomayor most emphatically did not. Neither did New York or Rolling Stone. As CNN and to a lesser extent NPR kept their reporting neutral. Breyer, aghast at the apparent effrontery of the majority, stood on the Everson and other religion-hostile precedents. He invoked the non-legal phrase play in the joints to describe how to satisfy the establishment and free exercise clauses together. But mostly he argued that the establishment clause existed to prevent anguish, hardship, and bitter strife from sectarian warfare. But Breyer argued not from the Constitution, nor even from any notes by Madison or Jefferson. Instead, he argued purely from Supreme Court precedent post-Blaine. When he did that, he evidently refused to recognize that there's a new sheriff in town, or an old one. And by the way, let's capitalize those words, sheriff and one, by reason of whom those two words are appositives for, namely God, regardless of what anybody else thinks. The point is, Breyer's own views of how to interpret the religion clauses to avoid religious strife are of no moment. The only strife this country has seen is between the faithful and the atheists. Beginning with Blaine, the atheists have had the upper hand. Breyer might be copacetic with that, but he cannot justify such a position with flawed case law. One cannot avoid strife forever with lies. Sotomayor continues the error. Furthermore, she tries to distinguish between Carson on the one hand and Zellman, Trinity, and Espinosa on the other. But she may not do that. In point of fact, she regards Zellman as equally erroneous and threatening to secular liberty. So on her own terms, that would be a distinction without a difference. New York Magazine, as I already said, illustrates its article with a James G. Blaine portrait. Furthermore, they lament that Montana's Blaine Amendment clearly fell in Espinosa. The Federalist Society noted that the Trinity Lutheran decision did the same to Missouri's Blaine Amendment. But at the end, they write, and I quote, Blaine and likely Jefferson are likely rolling in their graves, unquote New York Magazine. Well, Blaine certainly is rolling in his grave, but not Jefferson. Again, Jefferson intended to protect churches from having to curry favor with the government. Nothing in his writings suggests that he would have the government explicitly teach and favor atheism, as Blaine did. Rolling Stone goes completely off the rails, but hey, what do you expect? 6 years ago, they called explicitly for a repeal of the Second Amendment. In that call, they displayed all the magical thinking that typifies the left. In this case, it calls for working some kind of magic to remove all guns except those in possession of law enforcement officers, active duty military, very important persons, and their bodyguards. Today, they express horror that the Supreme Court in the New York gun case will let people other than those four categories carry guns in New York. They express further horror that the court will let coaches pray with their teams, tell immigrant visa applicants to wait outside our borders, and tell the EPA to go pound sand with their power curtailing regulations. Yesterday, the Supreme Court spoke with a loud majority voice. The framers of the Constitution never sought to build an atheistic or secular country. Those who suggest that they did should remember John Adams saying that our Constitution was for a moral and religious people. 12 states never added Blaine amendments to their constitutions. They are Arkansas, Connecticut, Iowa, Maine, big surprise there. Maryland, New Jersey, North Carolina, Ohio, Rhode Island, Tennessee, Vermont, and West Virginia. Louisiana did pass a Blaine Amendment in 1921, but repealed it in 1974. And in line with making America a civilizational state, I want to see a mass movement to repeal all remaining Blaine Amendments. The Supreme Court in Carson as good as said, all Blaine Amendments violate the federal Constitution. You Texans hoping to create a secession study committee, take note. You might want to scuttle your Blaine Amendment as part of turning Texas back into a republic. The hostility to religion on the part of federal and state governments must end. This case has highlighted one necessary way to bring it to an end. Now, what will Maine do? Will they throw up their hands and cancel all tuition assistance, or will they repeal their 1981 Blaine Law? Their legislature will not reconvene until September. Or will the governor call a special session? Stay tuned. Links to the description of the article, to the Carson opinion, to a map of all states showing which ones have Blaine Amendments in place and which don't, and to conservative news and views. I have another link to the awesome CNAV Store and to BitNext, as I also mentioned. And if you like what you've heard, you can like this video and subscribe to this channel. This is Terry A. Hurlbut delivering another declaration of truth and reminding you to let the truth set you free.